Government Order of the Day number 3.
Immigration Amendment Bill, third reading.
The Honourable Michael Woodhouse.
Mr Speaker, I move that the Immigration Amendment Bill be now read a third time. This bill forms part of a wider package of measures aimed at deterring people smuggling ventures from targeting New Zealand. The bill will also enable the effective and efficient management of a maritime mass arrival should one occur. The bill was introduced last year and was considered by the Transport and Industrial Relations Select Committee, reported back by the committee in August 2012 and was read a second time in April of this year. A mass arrival of asylum seekers has the potential to quickly overwhelm the ability of the New Zealand immigration system and the courts to manage the number of asylum claims. The arrival of a vessel carrying asylum seekers also has significant security and resource implications. Mr Speaker, as the previous Minister of Immigration, the Honourable Nathan Guy, said in the first reading speech, and I reiterated in the second reading speech, New Zealand cannot afford to ignore the risk of a mass arrival reaching our shores. Recent experience has shown that we are a target for people smugglers and we can't afford to be complacent. I hope a mass arrival doesn't occur, but hope and a head-in-the-sand attitude won't reduce the risk or increase New Zealand's readiness. It will happen, and when it does, this bill will ensure that we can effectively manage it. I want to summarise what this bill does. It introduces a definition of a mass arrival. This is now, thanks to an amendment by the Committee of the Whole House, set at an arrival of a group of more than 30 people. The bill introduces a provision to enable those who arrive as part of a mass arrival to be detained, if necessary, under a group warrant for up to 6 months. The bill will also allow this detention period to be extended by up to 28 days at a time, as determined by a district court judge. Detention will enable the relevant agencies to inquire as necessary into the backgrounds of the asylum seekers, pending decisions on refugee or protection claims. This will help confirm identity and assess whether the asylum seekers pose a risk to national security or public safety. The bill also establishes provisions that will help ensure the efficient processing of asylum claims and subsequent appeals. These changes apply to all asylum claimants, not just those arriving as part of a mass arrival. I also took the opportunity during the committee stage to introduce a supplementary order paper that will amend the Act to support people smuggling prosecutions that were not captured under Section 98C of the Crimes Act. This oversight was highlighted by a case recently where a Thai woman accused of smuggling migrants had her case dismissed because the offence she committed neither met the people smuggling definition of the Crimes Act nor the aiding and abetting offences set out in the Immigration Act. I also want to highlight what this bill does not do. It does not introduce arbitrary detention. It does not breach our international obligations to refugees and asylum seekers. Opposition members claim it breaches Article 31 of the Refugee Convention. Mr Speaker, for the benefit of those members not versed in the articles contained in the Refugee Convention, Article 31 states that countries shall, quote, not impose penalties on account of their illegal entry or presence on refugees who come directly from a territory where their life or freedom was threatened and who enter or present themselves without authorisation. Article 31 goes on to say that states shall not restrict the movements of asylum seekers and refugees, quote, other than those which are necessary, and such restrictions shall only be applied until their status in the country is regularised, end quote. This bill does not use detention as a penalty. And once the identities and circumstances within the group are understood, their immigration status can be regularised as appropriate and detention would no longer be necessary. Mr Speaker, it does not breach the Bill of Rights Act, despite the ridiculous rant by Mr Cunliffe in the Committee of the Whole. In fact, the Ministry of Justice confirmed in their Bill of Rights Act vet, dated the 2nd of April 2012, that the bill is consistent with the Bill of Rights Act. I would like to quote from that very Bora vet, quote, We have concluded that the bill appears to be consistent with the rights to be free from arbitrary detention and the right to judicial review as affirmed in sections 22 and 27(2) of the Bill of Rights Act." End quote. The bill includes a number of safeguards that ensure detention is not arbitrary. Again, quoting from the Bora Vet, quote, "We consider that the bill contains the appropriate safeguards to ensure that detention is not and does not become arbitrary." End quote. Those safeguards include, firstly, an immigration officer may, but not must, apply to a district court judge for a warrant of commitment authorising the detention of members of a mass arrival group. The judge then needs to be satisfied that the warrant is necessary for the reasons set out in the bill. The judge is able to authorise a shorter period than sought. The judge can require the immigration officer to report at specified periods throughout the duration of the warrant on whether the warrant is still necessary, and an immigration officer can seek a variation of the warrant at any stage. And finally, Mr. Speaker, it does not mean that this government is no longer committed to providing excellent support to refugees and asylum seekers. Accompanying the bill is two key policy changes intended to discourage people smugglers from exploiting vulnerable people by attempting to reach New Zealand via a mass arrival. They are: those granted refugee and protection status will initially be granted a 3-year temporary visa rather than residence. Their status will be reassessed after 3 years, and only if this reassessment is successful will they be able to apply for residence. 2, those granted residence after this reassessment will only be able to sponsor immediate family, a partner or dependent children, for entry to New Zealand, rather than being able to apply to sponsor wider family, such as siblings, parents or grandparents, as those granted residence under refugee categories are able to do. The policy changes that accompany this bill aim to deter people smuggling ventures by showing that New Zealand is not a soft touch. In the event that a boat does manage to reach our shores, we want to be ready, and this bill provides a way for managing such arrival efficiently, effectively and humanely. I want to thank everyone who helped support the passage of this bill: the previous Minister of Immigration, Honourable Nathan Guy, the Transport and Industrial Relations Select Committee members and the 33 submitters to the committee. I'd like to acknowledge the contribution of Chairman David Bennett, who managed very well throughout the process. Mr. Speaker, I commend the Immigration Amendment Bill to the House.
The question is that the motion be agreed to. Darian.